Hi, everybody. This is Samantha from the law offices of Samantha Wolfe, and we're here today for our next monthly virtual seminar. We try to do monthly seminars to educate our clients, referral sources about different documents or legal concepts. So we really appreciate you joining us today. Today, we're going to talk about the healthcare power of attorney, mental health power of attorney, and the living will, and talking about all the different ramifications of the document, when it's effective, when we need it, why you have it, all of those good things. So let's go ahead. We're going to share the screen and let's dive into our PowerPoint presentation. One of the reasons that we like to do these PowerPoint presentations is because part of our mission statement is to help educate clients and referral sources. So we do this monthly in order to be able to continue that education. Just so you know, you can access our YouTube channel directly through our website, or you can type us into YouTube, and we have all kinds of virtual seminars, short videos. We also have a series called Partnering with the Pros, where we try to talk to other professionals so that you can be able to hear information. We ask them questions. So you can check all of that out on our YouTube channel. Today, we're continuing our theme of naming our virtual seminars after songs. So last month we did one talking about She Works Hard for Her Money, where we talked about the financial power of attorney. And today our seminar is called Staying Alive, the mental health power of attorney, the healthcare power of attorney, and the living will. Our office is located at 20 East 6th Street in Suite 206 in Waynesboro, and you can always reach us at 717-655-2676. Let's talk about all of the healthcare related power of attorney documents. If you want to know about our financial power of attorney, you can check out last month's virtual seminar where we spent the whole time talking about the financial power of attorney. Today, we're going to focus on the healthcare documents, specifically 3 of the power of attorneys that we recommend our clients have. So we have the healthcare power of attorney, the living will, and the mental health power of attorney. And we're going to talk about each of these documents and why we recommend them. So let's start with the healthcare power of attorney. So the healthcare power of attorney is the document that is used if you would be unable to express your wishes to the physician. So what that means is that expressing can be verbal, it can be blinking, it can be squeezing a hand, it can be writing. If you're able to do any of those things, then a physician would determine that you're able to express your wishes. And as long as you're able to express, then your healthcare power of attorney document is not needed. If, however, you'd ever be in a situation where you're unable to express your wishes, that's where the healthcare power of attorney document comes in. Important thing to know about the healthcare power of attorney is we have no end of life wishes in the healthcare power of attorney, because this document is not designed to cover anything where you would potentially what we would call the pull the plug document. That's not the healthcare power of attorney's purpose. It really just authorizes your agent. That's the person who you are appointing. So it might be a spouse, it might be a child, friend, whoever it would be. They're actually legally called the agent under the healthcare power of attorney. And it's going to authorize the agent to make medical decisions. It can allow them to consent to surgery, to admit or discharge you from a hospital or nursing home. We always include a HIPAA release right in our healthcare power of attorney. The HIPAA release is the federal regulation that was passed in 1996 that says that if you sign a HIPAA release, then your agent can have access to any medical information that you might have. They can talk to the doctor, get prognosis and treatment options. So we actually put that right in our healthcare power of attorney. We recognize that most clients probably have a HIPAA release that they've signed with their primary care physician, but we put it in the healthcare power of attorney because that way, no matter where you are, what medical institution you're in, what state you're in, this allows your agent to be able to access your medical records. So we actually put it right in the document. We also typically in the healthcare power of attorney will discuss things like organ donation, cremation, or burial wishes. We don't put it in your last will and testament. We actually put it in your healthcare power of attorney and your living will, so your agent knows what you want as far as how to dispose of your remains, whether or not you want organ donation. That's important because if they are making decisions because you're unable to express your wishes, we want them to know ultimately what you want done upon your death. So we always put that in the healthcare power of attorney as well. Now, the healthcare power of attorney and the living will, sometimes attorneys put them together in one document and they call that the advanced healthcare directive. So in our office, we separate them into two separate documents. We have the healthcare power of attorney and then we have the living will. The reason that we do them as separate documents is because they're actually legally effective at different times. The healthcare power of attorney is if you can express your wishes, but there are no end of life wishes in the healthcare power of attorney. The living will, however, outlines if you would be terminal and unable to express your wishes and you would have no realistic hope of recovery, then the living will is effective at that time. So it's kind of the pull the plug document, and we separate them for that reason. So that way nobody's confused about when each document can be used. The other thing I wanted to mention about the living will is sometimes clients get living wills confused with their last will and testament. So your last will and testament is when you die, where do you want all of your stuff to go? Your living will, however, is while you're living, if you're unable to express your wishes to the physician, and again, like we talked about, expressing can be verbal, blinking, squeezing a hand, writing. If you're unable to express and you have a terminal diagnosis with no realistic hope of significant recovery, the living will outlines what you would want in those situations. So most people that we meet with, they would say, I want to be kept comfortable. I'm okay with an IV being used to deliver pain relieving drugs. And they'll also say that they're okay with hydration if it's used to keep you comfortable. So that way you're not dehydrated. But most clients would say they don't want any life prolonging procedures. And typically how we define the life prolonging procedures is that would be CPR, a breathing machine, dialysis, surgery, radiation, chemotherapy, antibiotics, and a feeding tube. So the thought behind the document is if you can't express your wishes and you have a terminal diagnosis with no realistic hope of significant recovery, you would not want your life to be prolonged. Now, the one aspect of that I get questioned about is antibiotics. And remember, this is only if you cannot express your wishes and there's no realistic hope of recovery and the antibiotics are considered life prolonging. If the antibiotics would be used to clear an infection, then we're not talking about that type of antibiotics. We're talking about the type of antibiotics where you have to stay on, otherwise you're going to continually get pneumonia, then pneumonia never clears. That would be a situation where we would be talking about the antibiotics being life prolonging. Now, clients can tailor that and change that to be whatever they want. Sometimes we have clients that say if they can't express their wishes and there's no realistic hope of recovery and they've been in that condition for so long, then they want their living will to kick in. We also have some clients that do want antibiotics, that might want a feeding tube under certain situations, and so we can always tailor that language. The other thing that's important to remember about the living will is that our document does allow the agent to use that as a guide, but to ultimately express what you would want in situations where you cannot. So we saw this with COVID during the pandemic. We had certain clients that might have gone on to a ventilator so that their lungs could heal. The living will would not be effective in that situation because either A, the client consented to it, or B, the physicians were thinking there would be a realistic hope of recovery. So the living will would only come into play if somebody went on a ventilator and then their health declined to the point where there was no realistic hope of significant recovery, then the living will would kick in. The other thing about the living will is we do recommend that has a HIPAA release in it. Same thing that we talked about with the healthcare power of attorney. We want your agent to be able to access your medical and hospital record and any information that would be pertinent to your physical or mental health so that way they can make the best decisions for you. So we actually put the HIPAA release right in the document. We also do put the organ donation or the cremation or burial wishes in the living will, just like we do the healthcare power of attorney. This is sample language of documents that we have seen as far as the artificial nutrition and hydration. So the first paragraph is just saying that, this would be if it would be prolonging the moment of death or you would be in a permanently unconscious state. And this is saying that I authorize my agent to direct that all forms of artificial nutrition and hydration, intravenous and peritoneal feeding, thank you, had trouble pronouncing that word, and all forms of tube feeding other than normal eating and drinking by mouth used to provide me with nourishment and hydration be withheld. If previously started, direct that they may be withdrawn. My only concern about this language is I typically recommend that clients separate the nutrition and hydration because, again, you may be okay with hydration if it's used to keep you comfortable or if it's helped to deliver those pain relieving drugs. So we usually have our documents say artificial hydration is okay if it's used to deliver those pain relieving drugs or if it's to keep you comfortable, but no artificial nutrition. Okay, before we go to the mental health power of attorney, the other thing I wanted to talk to you about related to the healthcare power of attorney and the living will is sometimes I get questions about whether or not you should give these documents to your agents who you've appointed or to your healthcare providers. So the first thing is healthcare providers more and more are asking or requesting whether or not you have a healthcare power of attorney and a living will. So I tell clients that as long as you feel comfortable, you can provide a copy to your medical provider. Typically now there's a patient portal and they can upload the document right to your patient portal so that any medical provider within that network can access your healthcare power of attorney and your living will. As far as giving it to your agent, there's no reason not to, other than if you would change your mind, you would have to go back to that individual and say, never mind, we revoked it or we appointed somebody else. But other than that, if you feel comfortable with the person you're appointing, there's no risk of them being able to use the document prior to when you would be unable to express your wishes. So you're welcome to provide your agent with a copy of the healthcare power of attorney and the living will. No issues there. Let's move to the mental health power of attorney. So this document has two different camps as to whether or not we should do a mental health power of attorney. So let me explain what it is, why it's used, and then we'll talk about the two ways that you can handle it. So a mental health power of attorney is specifically designed for people that have mental health concerns. They might have a diagnosis, bipolar, schizophrenia. But then we also have a second group of people as we age that are concerned about dementia and Alzheimer's. And Pennsylvania does not have an ideal way of addressing this, meaning that they don't have a separate document for dementia or Alzheimer's. They group all the mental health concerns together, which I do think is a problem, but currently Pennsylvania doesn't allow a way to distinguish between them. So when we're talking about a mental health power of attorney in this context, for most clients, we're talking about it in the context of dementia or Alzheimer's. Under your healthcare power of attorney, your agent cannot consent to any treatment that would be experimental. So when we're talking about Alzheimer's and dementia, sometimes there might be a drug that's experimental for federal funding purposes to get certain backing, financial support. So it might be considered experimental. If you would have dementia or Alzheimer's and your agent would want to consent to that drug trial or that experimental treatment, unless you had a mental health power of attorney, your agent under your healthcare power of attorney could not consent if you were unable to. So a mental health power of attorney can be really helpful for our clients that do have dementia or Alzheimer's. So it's used for drug trials, experimental treatments. It doesn't mean that your agent has to consent to it. It just gives your agent the ability to consent to it if they would feel that's in your best interest after talking to your treating physician. So that's why a mental health power of attorney is used in Pennsylvania. It does typically have a HIPAA release embedded in the document, just like the healthcare power of attorney and the living will. The problem with the mental health power of attorney is that it has an automatic expiration date. So if you would sign your mental health power of attorney today, 2 years from today, it would automatically expire. Now, the caveat to that being, if you would lose capacity in the 2 years, it does remain in effect. But if at the end of the 2-year period, if you have capacity and would have the ability to re-sign, Pennsylvania is going to require you to re-sign a mental health power of attorney. Now, most of our aging clients still opt to sign a mental health power of attorney because what we do is we notify you at the end of the 2-year term and you can come in and re-sign your mental health power of attorney so that it stays in effect for another 2 years. We also have another group of clients that make the decision not to sign a mental health power of attorney. And their reasoning for that is that if they would ever get a diagnosis of dementia or Alzheimer's, they would sign a mental health power of attorney at that time. Same 2-year rule applies. So at the end of the 2 years, if they have capacity, they would have to re-sign. But some clients don't like to have to come back every 2 years to the attorney's office to re-sign. Now, I always tell clients in some ways, every 2 years is a great way for the attorney to review your estate plan with you, make sure your documents are updated to what they want so that you can make any changes. But I always like to explain the two different camps using the mental health power of attorney. You can go ahead and do it and just know every 2 years you're going to have to re-sign it. You can also roll the dice and say, if I ever get a diagnosis, I'll certainly sign a mental health power of attorney at that time. The other way you can handle it is you can say, under no circumstances would I want anything that would be experimental or a drug trial, so you wouldn't sign a mental health power of attorney at all. That just means that your agent would not be able to consent to anything that would be a drug trial or that would be experimental. Okay, let's talk about the living will and the differences between the living will, the POLST, and the 5 wishes document. So we actually did a whole seminar where we talked about the 5 wishes document and the POLST. Let me explain a little bit about those documents. So a living will is a legal document where you are appointing somebody to make decisions in the event that you would be unable to express your wishes and you have a terminal diagnosis. A POLST, however, it is a physician's order that becomes part of your medical record. So it's Pennsylvania's ongoing life-sustaining treatment document, and it has to be signed by a physician. Now, the difference there is a living will is not part of your medical record. Instead, it's just appointing who you would want to be your advocate in the situation in which you couldn't express. The POLST is actually where you're saying whether you'd want CPR or resuscitation, and it would become part of your medical record. So my only concern with the POLST is that sometimes if you're healthy and you sign a POLST, I think it's done a little bit prematurely, just because I would want, if it were me, I would want the physicians and the medical providers to always talk to my agent to ensure that that's what I would want in this specific circumstance, where a POLST again becomes part of your medical record and is the physician's order. The 5 wishes document is a document that Pennsylvania has created along with a lot of other states. If people don't have a living will, they can access a 5 wishes document, and that can allow somebody to make their decisions for them. But let's go into a little bit more of the differences between them. So here's a nice chart that goes over that. So a living will is for anyone age 18 and older. A POLST is for any age, and the 5 wishes document is for any age 18 or older. For the living will, who can use it? It's anyone regardless of their current health. A POLST is designed to be used for only those who are seriously ill or frail. And the 5 wishes is anyone who cannot make their own healthcare decisions. So that is one of the big differences between the documents, is along that row there about who can use it. So again, it goes back to, for the POLST, you might not want that to be part of your medical record unless you do have a diagnosis or you really are seriously ill or frail. The difference dealing with the EMTs in the hospital, so this tells the EMT in the hospitals what medical treatments can be used in an emergency situation. So a living will does not do that. Again, the living will is just designating the person that can make those decisions if you'd be unable to express that. But it doesn't actually say what options you would want or what medical treatments you'd be fine with. The POLST, however, does tell the EMTs in the hospitals what medical treatments you'd be okay receiving. And a 5 wishes document also does not tell the EMTs or the hospital the medical treatments. Again, it's more designed to appoint the individual so that the medical providers are talking to the individual you've listed under the 5 wishes document. As far as the next row, guiding patient treatment when staying in a facility or a hospital, a living will does do that, a POLST does do that, and a 5 wishes document does do that. Then the last row is appoint someone to make healthcare decisions on your behalf. A living will and a 5 wishes document does do that. A POLST does not. Because remember, this is a document where you've already decided what you're okay with, and so it becomes part of your medical record. So a POLST is different than the living will and the five wishes document. So again, I would recommend anybody who would have a diagnosis or as they're aging would become seriously ill and frail, I think a POLST would be an appropriate document at that time. I'm just looking at from this perspective of if you have a living will or a five wishes document, that's really then giving somebody the ability to make decisions for you and doesn't really become part of your medical record. So a POLST is used to direct immediate medical treatment. A living will is used to direct future decisions about medical treatments, meaning I'm not in this condition yet, but if I ever get in this condition, this is who I want to be able to make decisions if I would be unable to. The living will also provides guidelines of what you think you would want, but again, it's ultimately the decision of the agent under the living will. So why is a living will important? So a living will is important because it allows you to express your wishes in writing when you cannot physically express them. So it's you thinking ahead and saying, if I would ever get in this situation, this is what I would want. So it allows you to think it through and be in control and kind of empower your agent to make the decisions that you think you would want. It does provide clear instructions to the emergency medical staff. And the presence of a living will can help provide your family with some relief and some sense of direction. So I always tell clients that when your agent is fulfilling what you've outlined under the living will, the benefit is they're not having to make the decision. Instead, you've already provided the guidelines and the outline for it. They're just following what you have expressed. So we don't have to worry about somebody actually having to decide to pull the plug because you've already outlined your circumstances and situations in which you would not want your life to be prolonged. So take some of the burden off your agent. Now, the POLST is the physician's order for life-sustaining treatment. It's a medical form completed by a doctor, a nurse practitioner, or a physician's assistant in consultation with the patient. And it does allow people with serious or chronic illnesses, or if they're frail at a certain age, to spell out what kind of medical care they would want. And that would be in future medical emergencies. So again, a POLST is that physician's order that becomes part of your medical record. The five wishes document, I wanted to show you what we have here in Pennsylvania for the five wishes. Again, in other states, they do have the five wishes document as well. It's designed to be a uniform document that can be used across states. So this is what your five wishes document looks like. And our office really came into contact with the five wishes documents because we had some clients that were in a nursing facility. We had gone out to their house and they had signed a healthcare power of attorney and a living will. But for whatever reason, one of the medical providers, the networks here in our geographic area, had somebody go out, talk to the client, and have them sign a five wishes document. The issue is that the five wishes document then superseded the living will that we had prepared for the client. And the living will specify different things than their five wishes document. And it also didn't have as much detail as the living will did. So we actually had to reach out to the client and explain to them that once they signed the five wishes document, their living will was no longer effective, and explain why the living will was actually a more helpful document for the agent because we had spelled out more information and more direction. So I think that when we're talking about quality of documents, a lot of times you might get a more in-depth document if you meet with an attorney and outline what you would want. A five wishes document is always going to be better than nothing, but the problem with the five wishes document is typically it's not done by an attorney who's outlining all the legal ramifications for the different provisions. So I would encourage anybody who's considering a five wishes document and a healthcare power of attorney and living will to talk to an attorney about the differences. Maybe the attorney can explain why a living will might be helpful in your particular circumstance, or might talk a little bit about the different language that you could use as opposed to what's in the five wishes document. This is a copy of the five wishes. We just took a picture, talks about what is it, who should use it, talks about how do you change the five wishes document. So this is outlining for medical treatment that you do or do not want, and it talks about what life support treatment means. It talks about the person that you choose. And again, there's nothing wrong with the 5 wishes document. Sometimes I think a living will, though, can more accurately capture what you would want in certain circumstances if the attorney is drafting it properly and give more detail. So again, you just want to talk to your physician, talk to your attorney, and make sure that you're actually signing a document that addresses what you want. As you can see, as we're kind of advancing the slides, the 5 wishes document definitely has more standard language, where a living will, it allows you to really modify the language for whatever you want. So when does the 5 wishes document take effect? So you will always make your own decisions if you're able to talk to the doctor and understand what's being said. The 5 wishes is an advance directive which only takes effect when you're too ill to communicate it. So if you're unable to make your own decisions, speak for yourself, then your 5 wishes document comes in. So again, it's more like the living will. It's not a physician's order. It's just really capturing what you think you want and appointing the person that can express that for you. Is the 5 wishes a legal document? Yes, it is. It was written with the help of the American Bar Association's Commission on Law and Aging. So it does meet the legal requirements of 46 states. It's used widely in all 50 states, and a few federal law requires medical care providers to honor patient wishes as expressed. So again, 5 wishes document is still helpful. It can still be effective. It just outlines certain things that you want, and then it would go into effect if you can't express your wishes. But again, it's something that the American Bar Association created a commission on law and aging to kind of address the issue of circumstances where people aren't getting living wills. And the 5 wishes document is an alternative to that. My preference is still the living will and the healthcare power of attorney, because I think it can be more tailored to what you want. But that's why we have the 5 wishes document. Does the 5 wishes meet the HIPAA requirements? So the centers, let me explain why this is important. In our living will and our healthcare power of attorney, we have the HIPAA release embedded in the document. If you look at the 5 wishes document, the 5 wishes document does not have a HIPAA release in it. So when you're looking at it on the surface, it doesn't look like it has the HIPAA release. However, the Centers for Medicare and Medicaid Services have ruled that the agent or proxy appointed under the 5 wishes is treated as the patient's personal representative under HIPAA and has the same access to your medical records and information as the patient once the advance directive does take effect. So I wanted to make sure people understood that. Now, again, my preference is to still have the HIPAA release so that way we're covered no matter what circumstance, but I wanted to make sure that everybody knew that. How do you use the 5 wishes document? You review the document with your family. You fill it in. Like you saw, there were some blank spaces, so you fill it in. You follow the directions in the document for signing it. You discuss it with your healthcare agent, so that's the person you're appointing to speak on your behalf, and your doctor, and you give a copy to each of them, so that way they have it, just like you would with a living will. And you make sure a copy of your 5 wishes is placed in your medical file by your doctor, just like you would if you were doing a living will. And then you discuss your 5 wishes with your family members so that everybody's on the same page about what treatment options you want. Does the 5 wishes document need to be notarized? So this is depending on the state. So if you live in North Carolina, South Carolina, West Virginia, or Missouri, you must have your 5 wishes document notarized. If you live in any other state, a notary is not required. What's interesting to me is in Pennsylvania, a living will and a healthcare power of attorney must be witnessed by 2 witnesses, but it does not have to be notarized. Although in our office, we do notarize it. It's just good practice. Because the reason that you have the witnesses and the notary there is so that we can ensure that you are actually signing this document. Where if you don't have a notary and you don't have a witness requirement, then there's always the question of, did you actually sign it? Did you know what you were signing? So that's why in our office, we lean more towards the living will and the healthcare power of attorney, and we do have it witnessed and notarized. So that way there is no concern about whether or not the person actually signed the document. Let's talk about a do not resuscitate or a DNR. So what is that order? It is for individuals who are terminally ill and do not want to be brought back to life via CPR, defibrillation. How do I say that? Defibrillation. You know what I mean when they do the paddles, or other related options. That would be a DNR order. So again, that's a physician's order that is on your chart, and you can do a DNR separate from a POLST, but the POLST does also have a DNR option on the POLST. Okay. So I know that that was a lot of information. So what I'm going to do is I'm going to talk about next month. I will stop recording and I'm happy to answer any questions anybody has. So like I said, we always do monthly virtual seminars. So in the theme of naming our virtual seminars after songs, on June 6th, we're doing Knocking on Heaven's Door, The Last Will and Testament. We wanted to do smaller, shorter seminars that address the basic estate planning documents for our clients and referral sources to be able to access. So we'll be spending that 30 minutes on just the last will and testament. If you want to be a part of that virtual seminar, you can email Amy Meek at her email, which is listed there. You can call or text our office, or you can also do it through our website. Just like we talked about before, we do record all of our seminars, and then we do post them on YouTube after, as well as across our social media platforms. So you can always access it after if you're unable to make that virtual seminar. Okay, let me close us out and then I'll be happy to take any questions. So thank you so much for joining us. This was this month's virtual seminar where we talked about healthcare power of attorneys, living wills, POLSTs, the 5 wishes document. I hope this provided a little bit of insight about the different documents. If you have questions, you can always reach out to our office at 717-655-2676. This is Samantha with the law offices of Samantha Wolfe. Thanks so much for watching. We look forward to seeing you next